Welcome back, everybody, to our studies in land law. We are now on to topic number 8 of this godforsaken subject, and we're moving on to the subject of easements. Easements are particularly interesting. They have certain interesting elements to them. It won't be a particularly long topic in reality, and this is actually the third to last topic we're going to be covering, at least for free content. There are some members only subject topics that we will do as well, but for the most part, we're going to do easements, we're going to do freehold covenants, and then we're going to do mortgages. And then when we look at members only content, we're looking at, I believe, leasehold covenants and adverse possession, and I think one other topic as well. But for now, topic number 8, this is the subject of easements. So this topic is going to, or at least this video specifically, is going to examine what an easement is, what are the requirements for an easement, especially for the creation of an easement when it comes to law. So, two questions we're really going to be asking is what is an easement, number one, and then number two, how are easements created in law? In answering number one, it is quite simple. An easement is simply a right over a piece of land for the benefit of another piece of land. So, essentially and simply put, if I have some land that I have some interest in land that I wish to benefit from, but in order for me to benefit in this land or to have the full and total enjoyment of the piece of land that I own, I must have an interest in a different piece of land that is known as an easement. Okay, so in order for one to benefit from a piece of land, they must have some right in another piece of land over another piece of land in order to actually get access to that right. Then we have an easement. And a good example of this is a right of way. If you have some piece of land, but in order to actually get to that piece of land, you have to be able to travel through a different piece of land, then you have a right of way. And this is a proprietary interest. This is an easement that is a proprietary right in rem over that other piece of property. Fundamentally, if the key requirements for an easement are present, it will have the ability of having proprietary status as per Section 1, Subsection 2 of the 1925 Law of Property Act. So it has quite significant advantages. It has significant legal rights and legal interests. Now, in order to find the key requirements for an easement, we don't actually look to the statutes, we don't look to the legislation, we look to the common law. We look to the case of Re Ellenborough Park. This is one of the most important cases in land law, so make sure you understand it. And fundamentally, we will go through it and think about what the requirements for easements are as a result of this case. Now, this case specifically involved a house which was near Ellenborough Park. Now, it had been granted the right to use the park as part of a leisure garden up until World War II. At which point, the government had taken over and taken control over the entirety of the property. If this was determined to be an easement, and as a result of which it would be determined that they had a legal right, then this would mean that the government would have to pay compensation for the deprivation of said legal right. If it was not an easement and therefore only a right in personam, then there would not be this same kind of compensation requirement. The courts held that, in order to make a determination as to the existence of an easement, there must be 4 requirements, and if, in this instance, an example, these 4 requirements are met, then an easement does exist. The requirements are as follows. Firstly, there must be the existence of what is known as a dominant and a servient tenement. Secondly, there must be accommodation of the dominant tenement. Thirdly, there must be a distinction between the dominant and servient tenements. And fourthly, finally, there must be a right which must lie in a grant. These are the 4 requirements that are outlined by the case of Re Ellenborough Park in relation to the creation of an easement. Let's then unpack each of these different elements and these different requirements. So what do we mean when we talk about dominant and servient tenements? What actually does this actually mean? And bear in mind that we're going to come on to this kind of language as well when we look at freehold covenants. So don't think that you can just forget about it as soon as we've finished our lessons on easements. So bear that in mind. Simply put, the dominant tenement will be the land that is able to benefit from the right, and the servient tenement is the land that is burdened by the exercise of the right. So let's say, for example, I have a house, and in order to get to the front door of my house, to get to the property, there is another piece of land, and therefore there has to be a right of way over that piece of land. The piece of land to which there is a right of way is the servient tenement, because it is burdened by the existence of the right. My right of way over and into my property is burdening the servient tenement. It is burdening that piece of land. And as a result, the land that I own, the house, is the dominant tenement. It is the part of piece of property that is benefiting from the right of the servient tenement. That's simply how it works. When an easement is acquired, there must be a clear identification of both a servient tenement and a dominant tenement. There has to be two pieces of property. One is servient, one is dominant. The next requirement, an accommodation of the dominant tenement. What does this mean? Well, accommodation in this regard simply refers to the improvement of the land which is subject of the dominant tenement. So there must be an improvement of the land as a result of this. It means the meaning of accommodation in this regards, therefore, refers to the enjoyment of the right in connection with the normal use of the land, okay? So there is an accommodation of the dominant tenement as a result of the enjoyment of that right in connection with an ordinary use of that land. This will be a question of fact, and it is one that will require an account of evidence, simply put. In addition to this, there has to be a distinction of ownership between the dominant tenement and the servient tenement. This is as established in the case of Rowe and Siddons from 1880. It makes it clear that you cannot enjoy an easement over your own land. So if we go back to the example of a house that I own with a right-of-way requirement over a different piece of land, if I just owned that other piece of land as well, then there wouldn't be any need for an easement, okay? There has to be a dominant tenement and a servient tenement, and they have to be distinctly owned by different people or by different organizations. This defeats the purpose of an easement if I just owned all of it, because the idea here is that I own a piece of land and I have to burden a different piece of land in order for me to have an ordinary enjoyment of that property. If I just own it all, then there is no need for an easement at all. So there must be a diversity of ownership. The final requirement is that the form has to be in the form of a subject matter of a grant. This is justified on the basis that an easement is a right which has the ability to exist at law. And so owing to the fact that it has to have the ability to exist at law, it must be capable of being granted by way of a deed. And so the final requirement, therefore, means that the granting of an easement will firstly require a grantor as well as a grantee, a person who grants and a person who, therefore, receives a grant. And it also must be capable of being defined. This has actually given rise to there being multiple different categories of easements. And these categories are as follows. We have easement of way, so for example a right of way, which is what I've been talking about in this lesson as an example. You have what are known as easements of support, easements of light and air, easements that relate to the rights of artificial waterways. There are, of course, other categories, but these are the most common. And when I think about and I carry on doing the different examples, for the most part, I'm going to be referring to easements of way, like rights of way. But we will look at cases that relate to other types of easements as well. It's just that it's easiest to understand easements in relation to rights of way because they're basic and they're quite intuitive to understand.